We'll start off with judicial matters. The Supreme Court has upheld the power of the president to declare a state of emergency in any state to prevent the breakdown of law and order or degeneration into a state of chaos or anarchy. The Apex Court, in a split decision of 6-1, held that such suspension of elected officials must be within a limited period. Justice Mohammed Idris held in the lead majority judgment that Section 305 of the Constitution empowers the president to deploy extraordinary measures to restore normalcy where emergency rule is declared. The judgment was on the suit filed by Adamawa State and 10 other PDP-led states, challenging the propriety of the state of emergency declared by President Bola Tinubu in Rivers State. Let's bring in lawyer Evans Ofili for more on this landmark decision. Mr. Ofili, thanks for joining us on the news this hour. Justice Idris held that Section 305 empowers the president to deploy what he calls extraordinary measures, and that the Constitution doesn't specify what those measures are. Do you think this judgment in a way effectively expand presidential powers in this regard?
Yes, it did. Even though the Supreme Court was very, very careful in making express pronouncements, the press helped the Supreme Court to blow up the story. Because what the Supreme Court is saying is that the Constitution says that the president can apply extraordinary means to restore normalcy. Okay, but didn't say the limit or extent of that extraordinary means or what it could be. In one way, the Supreme Court is saying that the president impliedly have powers to interfere with democratically elected institutions. That's what it's saying impliedly, because if the Constitution did not say or did not define what extraordinary means, means to restore normalcy, the Supreme Court also did not say that the president had the power to remove or suspend a democratically elected governor, his deputy, state house of assembly members, and the rest of that. You understand? So for me, the judgment is quite unfortunate. It's not one that I feel very elated or excited about. With due respect to the Supreme Court, the authorities, and the rest of that, I want to align myself with the dissenting judgment, which says that it's not right for the president to use the extraordinary means that is conferred on him by the Constitution to distort democracy. Okay, because it couldn't have been the intendment of the legislature that extraordinary means to restore normalcy will be placed on the president to get to the extent of distorting a democratically elected governor and the institutions thereof.
Indeed. Justice Ogwai in minority dissented sharply, and he insisted that while emergency powers exist, they cannot override democratic mandates. But talk to us about how significant this dissent is. Could it, for instance, shape future constitutional challenges or reforms despite being in the minority?
The dissent is not the judgment, it's not the precedent, it's the majority judgment that makes the precedent. In a way, the court have surreptitiously expanded the power of the president. Before now, we know where the power of the president starts in the issue of state of emergency. He can declare some money, but we don't know where it ends. That's the extent to which it can go in terms of. But now the Supreme Court impliedly have given it a boost to show that, well, since the court did not, since the law did not say what the extraordinary means could be, therefore it may be okay, but that in it have its own implication. And the implication is that the Supreme Court also did not say, why are they picking one and leaving the other? The Supreme Court also did not say that you can do that and use that to remove a governor. Because the mandate of the people, okay, the president's power cannot override the mandate of the people. The president on the mandate is on the basis of a mandate that his power exists. So he cannot be standing on a mandate and then procure the same power to distort the mandate of the people at the same time. So that's contradictory, and it's ridiculous to say the least.
For a bit, let's talk about future expectations, because this judgment will almost certainly be cited in future emergencies. What precedent has the Supreme Court now set for future presidents? And in the case of dictatorship within democracy, would you say we have sufficient legal checks to prevent abuse of emergency powers?
The little check that we have, which is embedded in the Constitution, is being eroded by the Supreme Court, with due respect to them. It's kind of judgment in the circumstance. I do not concur with this judgment in any way. I think that as much as the Constitution say that we shouldn't give the president that power. The check is critical. It's needed. Whittling down the president power is what's required. By law, that is what is supposed to do. But right now, we have a situation where it's just like the president being killed by the highest court in the land. And that is a danger, because in future we may have to run into more crises.
Good place to leave it. Lawyer Evans Ofili, thank you for talking to us.